So very good evening all the participants. Today is the first session and there is a reason behind it for starting with RDB and SARFAESI, because there might be cases which might be running under DRT or action might have taken under SARFAESI, because these acts are operative even prior to introduction of IBC. So it's very important to understand the interplay between IBC and RDB and SARFAESI, as well as both these acts are in our syllabus. So we'll start with this RDB and SARFAESI. We'll understand the various implications, where registration is required under SARFAESI, what is the minimum threshold, what are the penalty provisions, what are the appeal provisions, and so many other things. Taking possession, suppose possession was taken even prior to this coming in under CIRP. So what are the various scenarios? We'll be discussing all these scenarios. So Kajal Kiranji will be taking up the session and I'll be there and I'll intervene wherever it is required. But the session will be mainly taken by Kajal Kiranji. So Kajal Kiranji, it's all yours now, please.
Yes, sir.
So you can share your PPT also. I have made you co-host.
Sir, you please share this PPT.
Okay. Let me share the PPT. Sudhakar ji, can you share? Or anybody else? Shruti Pandey ji, anyone who is on laptop?
Yes, sir, I can share.
Okay, please share. So I'll make you co-host if I have not. Just a minute. Yes. And please mute yourself, Dinesh Kalra ji. Yes, Shruti Pandey ji, please.
Sir, is my screen visible?
Yes. Make it full
Okay.
slideshow.
Right, sir.
Okay. Yes, Kajal Kiran ji, it's all yours.
Yes, sir. Yes, sir. Why we are studying RDB and SARFAESI Act together? No, it is. Next slide, please. Okay, why these two statutes together we are studying? RDB Act 1993 gives banks and financial institutions a specialized tribunal, that is DRT or DRAT, to sue for a debt and obtain a recovery certificate, a court route remedy. That means mainly this is the recovery mechanism for the banks and financial institutions to get their money back. SARFAESI Act 2002 gives a secured creditor a self-help remedy, enforcement of security without court intervention, subject to DRT oversight or challenge. So the main difference between RDB Act and SARFAESI Act is that in RDB Act we go to the court for the recovery, but in SARFAESI Act, without court intervention, the recovery is made. Now, according to Section 13, Subclause 10, SARFAESI expressly sends the secured creditor to the DRT under the RDB Act for any shortfall. The two acts are used in sequence, not as alternatives. So both these are used as a sequence and they are not the alternative acts. Both coverage converge on the same forum, that is DRT or DRT, and since 2016, both routes can be undertaken by the IBC the moment insolvency proceedings begin. So as soon as the insolvency proceedings begin, we go to the DRT or DRT for individuals and partnership firms.
No, actually, if an application is admitted under IBC, then IBC will take over. So the proceedings will stop by virtue of Section 14 of the IBC. For example, suppose some proceeding, suppose some proceeding is already going on under DRT. Now that proceeding will stop as it is once the moratorium is in force. I hope, Kajal Kiranji, I am correct.
Yes, sir. I just said that for DRT, if the debtor wants to file an application, then he can go to the DRT. In that sense, I said so.
Okay, please.
And yes, sir.
But since the basic emphasis here is on IBC, so
Yes,
both
sir.
routes can be overtaken by IBC. So
Yes,
IBC
sir.
will override the provisions of DRT
Provisions
or
of DRT,
SARFAESI
DRT or
once
SARFAESI. Yes, sir.
CIRP is commenced.
Yeah, moratorium will start.
Yes, please. Please carry on.
Okay. Why these two? No, it's over. Second slide.
Next slide, Shruti Pandeji. Next.
Next one.
Yes, from
Yeah,
here.
RDB Act key definitions. Now, debt, any liability, not interest, claimed as due from a person by a bank or financial institution or consortium in the course of business, secured or unsecured, assigned or under a decree legally recoverable on the date of application. Now, what is financial institution? Institutions notified by the central government and SC or RC registered under Section 3 SARFAESI and a SEBI registered debenture trustee. A creditor outside this definition has no DRT route. Now, what is pecuniary threshold? Act applies only where the debt due is rupees 20 lakh or more. Raised from earlier it was rupees 10 lakh. By notification dated 6/9/2018, the amount is now rupees 20 lakh. Central government may lower it but not below 1 lakh by notification. Now, debt due. Application lies to the tribunal where the defendant resides or carries on the business, or the cause of action wholly or partly arises, or any of several defendants resides.
So here, one important point to note is what is the pecuniary threshold. So they could ask a question on this because earlier it was 10 lakhs. So if they give you two options, 10 lakhs or 20 lakhs, then 20 lakhs you have to tick. Yes, please.
Next slide. Next slide. RDB Act forums, jurisdiction and civil court bar. DRT Section 3 and DRT Section 8 are established by the central government notification, which also fixes territorial jurisdiction, not by a high court order or state legislation. Both are single member forums. A DRT has one presiding officer, a DRT one chairperson, according to Section 4(5), which is exactly why procedural discipline before them matters. Section 17. The tribunal decides recovery applications from banks or financial institutions and exercises the Part 3 IBC jurisdiction. The appellate tribunal hears appeals from it. Section 18. Bar of jurisdiction. No court or authority may exercise jurisdiction over Section 17 matters except the Supreme Court and High Court. Under Article 226 or 227, a parallel civil suit above the threshold is simply not maintainable.
So participants, you can stop us anywhere and you can ask questions on any of the sections. Yes, please.
Now, RDB Act from application to recovery certificate. Section 19(1) to 3, original application by the bank or financial institution. Joint applications permitted where several institutions share a claim or one institution proceeds jointly against overall debtors. So, the application is filed under Section 19(1) to 3 in the DRT. Now, 19(4), summons requiring the defendant to show cause notice within 30 days. Section 19(8), subclause 8 to 11 allows set off and counterclaim. So, summons are issued in Section 19(4). Section 19(12) to 18, interim powers. Injunction, attachment before judgment, security receiver, where the tribunal is satisfied the defendant is about to defeat recovery. So if the defendant wants to sell off his assets or anything, then injunction order is passed under section 19, subclause 12 to 18. Now 1920 final order is passed, plus recovery certificate to the recovery officer is made. Section 1924 sets a 180-day disposal timeline directory, but it shapes how adjournments are viewed. So till 180 days, the process should be finished. Now, section 25 to 30, the recovery officer executes by attachment and sale, taking possession of secured property, appointing a receiver or arrest, and civil detention with a 30-day appeal to the presiding officer.
So at least they could ask you questions. One could be on set off and counterclaim. So whether set off and counterclaim is allowed, the answer is yes. Second could be appeal to the presiding officer. So at least these two things we must remember. Now regarding joint application, in case you are taking an action under SARFAESI, so 60% of the joint lenders should agree for initiation of a proceeding under DRT. So these three things you must remember out of this slide. Yes, please.
Yeah, next slide. RDB Act recovery flowchart application to execution. So first it starts from the original application is filed to the DRT according to section 19 subclause 1. Then the DRT issues summon within 30 and the show cause notice, and within 30 days they have to appear before the court. Then according to section 19(4), and then interim orders are made by the presiding officer in which injunction or attachment of property is done, or receiver is appointed under section 19 subclause 12 to 18. Now the final order is passed by the DRT, and when the debt is determined by the DRT, final order is passed under section 19 subclause 20, and recovery certificate is issued by the court to the recovery officer, and the recovery officer can execute, that is by attachment of the property, sale, possession, civil detention according to section 25 to section 30. Debt is recovered. When debt is recovered, then the certificate is satisfied, and the aggrieved party, if the party is aggrieved, then they can appeal to the DRAT. Appeal window is 30 days from the DRT's order, with a 50% reducible to 25% pre-deposit under section 21. See the appeal slide for the full disclosure. So, if one wants to appeal to the DRAT, then they have to deposit a 50% amount for the appeal in DRAT.
So at least two things we must remember from the screen. One is the appeal timeline, that is 30 days. And second is the pre-deposit. This 50% and 25%, at least this much we must remember from this slide on which questions are usually asked. Yes, please. Next slide. Next slide. Shruti Pandeji.
RDB Act appeals. So appeal from DRT final order in section 19 to subclause 20, and then the forum is DRAT in section 20, and limitation is 30 days from receipt of the order, and pre-deposit we have to give is 50% of debt determined, and it can be reducible to not less than 25% for reasons recorded in section 21. Now the recovery officer's order. Then we can appeal to the DRT, where the presiding officer under section 30, and the limitation time is within 30 days, and the pre-deposit amount under section 30A, pre-deposit on the same lines as section 21, that is 50% or 25% as determined. Now order with parties consent, where the order is made by the consent of both the parties, then no appeal lies. It is just like a consent decree, so there no appeal lies for this. And the recovery officer under section 26, correctness of the amount already certified cannot be re-registered before him. That is a merits question for the tribunal, not execution. Now RDB Act penalties and default consequences. Civil detention on default of a disclosure under section 19 subclause 4 subclause 2, detention in civil prison up to 3 months after an opportunity of being heard. Now, attachment before judgment, where the defendant is about to dispose of or remove property to defeat recovery, furnish security, produce the property or its value, or show cause. Under section 19, subclause 13. Now, void attachment is under section 19, subclause 16. An attachment made without complying with section 19, subclause 13 requirement is void. Disobedience of orders under section 19 subclause 17, disobedience of orders under subsections 12, 13 or 18, attachment of the defaulter's property and detention in civil prison up to 3 months.
Yes. So the important point to remember here is whether there could be criminal proceedings also. So you can study that point and write in the group whether only civil prison is there or there could be some criminal punishment also. Yes, please. Next.
Quick check. RDB Act. Facts. The DRT determined a debt of rupees 1.8 crore against Suresh Textiles and issued a recovery certificate. The company deposited only 25% and seeks to appeal to the DRAT on that reduced deposit, citing hardship. As a general rule under section 21, what must a defendant deposit with the DRAT before an appeal is entertained? 25% of the determined debt, 50% of the determined debt, 75% of the determined debt, no deposit is required. So the answer will be 50% of the determined debt. Can the DRAT reduce this pre-deposit and to what floor? No, 50% can never be reduced. Yes, for reasons recorded, but not below 25% of the debt due. Yes, the DRAT may waive it altogether. Only the central government can authorize a reduction. So the answer will be yes, for reasons recorded, but not below 25% of the debt due.
Now the examiner could ask you this question in a different way. The examiner may ask that, okay, Suresh Textiles has not represented for reduction, whether DRAT can reduce on its own to 25%. This way they could ask the question and you have to respond in the group, right? So I hope you got my question. Suresh Textiles has not requested for reduction in pre-deposit. Now whether the question is whether DRAT or its own motion can reduce it, yes or no? You can
No, sir.
write in the group. Okay, next. Yes, please.
Next slide.
SARFAESI
Next
Act
slide.
now.
This is the answer actually.
Right. So now we can go to SARFAESI Act.
Now, SARFAESI, object and 3 limbs. The Act does 3 distinct things: regulates securitization of financial assets, regulates asset reconstruction, and lets a secured creditor enforce security interest without court or tribunal intervention. Constitutional validity upheld in Mardia Chemicals versus Union of India, subject to the borrower's right to be heard, being read into the process. Only a secured creditor can invoke Chapter 3, Section 2, Subclause 1 ZD, a bank notified financial institution, ARC debenture trustee, or trustee holding securities on their behalf. An unsecured creditor has no locus under the Act at all.
But before we start this act, we must know the full form of SARFAESI. So what is the full form of SARFAESI? And sometimes they ask question on this. They will give you different full forms and you have to select the correct full form of SARFAESI. So Kajal Kiranji, please tell the full form to all.
Sir, the full form of SARFAESI is securitization and reconstruction
Of financial assets
of
and
financial
enforcement of
and
security
enforcement
interest.
of securities or interest. Yeah.
Right. So this we must remember. You must remember the full form and they will give you various variants of this SARFAESI. So the 3 may be wrong, and the correct one is securitization and reconstruction of financial assets and enforcement of security interest. This we must remember. Yes, please. Please, next slide.
Now key definition: secured creditor. Secured creditor is bank, notified financial institutions, ARC, debenture trustee or trustee holding securities for such lenders, the only class with locus to invoke the act. Security interest under section 2 subclause 1 ZF, right, title or interest of any kind on property in favor of a secured creditor expressly includes mortgage, charge, hypothecation, and assignment exclude items in section 31. Non-performing asset enforcement can begin only after the account is classified as NPA per RBI guide directions. Premature classification is the commonest ground on which a section 17 challenge succeeds. Asset reconstruction company must be RBI registered with prescribed net owned fund. On acquiring a financial asset, it steps into all rights of the transferring bank or financial institution. Now, SARFAESI applicability and exclusions. NBFC notification SO 856E dated 24/2/2020 treats NBFCs with assets greater than equal to 100 crore as financial institutions entitled to enforce security for secured debts of rupees 20 lakh and above, brought down from rupees 50 lakh by SO 652E 12/2021, and NBFC specific floor, not to be confused with a general section 1 subclause 4 threshold under the RDB Act. Section 31 carves out a lien under the Contract Act or Sale of Goods Act, a pledged security, interest in agricultural land, cases where the residual dues are below 20% of the principal, plus interest and financial asset not exceeding rupees 1 lakh.
So this is another favorite question from the examiner, that what is not covered. So if there is a security interest in agricultural land where the residual dues are below 20% of the principal plus interest, and if the financial assets do not exceed 1 lakh, then action under SARFAESI cannot be taken. So we must remember these things. Yes, please. Next.
SARFAESI section 13 step by step. Section 13 subclause 2, demand notice. Now 60 days to discharge full liability is given, and stating the amount and the secured assets to be enforced on non-payment. Defective notices are the second commonest ground of challenge.
Right.
Now section 13.
But before we issue a demand notice, we have to take some action also. So what is that action which the bank or financial institution has to take before issuing the demand notice? Anyone? They have to declare the amount as NPA. So unless you declare it as NPA, you cannot issue a demand notice. Yes, please.
Section 13 subclause 3A, borrower may represent or object within the 60 days. The creditor must consider it, and if rejected, communicate reasons within 15 days. Read into the act in Mardia Chemicals, later codified. Section 13 subclause 4, on default, take possession, including lease or assignment or sale, take over management, appoint a manager, or direct a debtor of the borrower to pay the secured creditor directly. Rule 2 subclause A, the authorized officer
Just
must
a
be
minute.
at least...
Before we move to Rule 2A, can you explain this directed debtor of the borrower to pay the secured creditor directly? Anyone? Directed debtor of the borrower to pay the secured creditor directly. Can anyone of you explain this? There could be a case where the borrower has to recover some money. So now what they will do? They will ask it to pay to the secured creditor directly and not to the borrower. So the borrower who is in default, he might be having some money which he is entitled to recover, right? He must be having something on the asset side. So we can direct the debtor to pay to the secured creditor directly instead of to the borrower. This is the meaning. Yes, please.
Rule 2A, the authorized officer must be at least a chief manager, that is public sector or equivalent. Action below that rank is without authority. Section 14, district magistrate or chief
Chief
CMM
Metropolitan Magistrate,
Chief
CMM.
Metropolitan Magistrate assistance for physical possession on a 9-point affidavit, order within 30 days, extendable to 60, a ministerial exercise, not an adjudication of the borrower's defense.
So if there is some resistance, so you can take assistance from district magistrate or chief metropolitan magistrate. Normally, they will act within 30 days, but it may be extended to 60 days also. And DM may suggest the police to help the secured creditor to take the possession. Yes, please. Next.
Sir, I have a small doubt, sir.
Yes, please.
Sir, now the recovery process is on,
Right.
and it is and the district magistrate is taking action.
Right.
During that period, if the borrower wants to pay, is it allowed, sir?
Actually, we'll come to that in SARFAESI Act. But before that, no, he will not be allowed. Actually, he has to approach the DRT only. SARFAESI Act is basically a procedural law. All actions will be taken under DRT only, Debt Recovery Tribunal.
Right,
So he has to approach the Debt Recovery Tribunal.
Right, sir. So within that 60 days, he can opt to pay, but not after the 60 days as per section 13(3)(a).
Right. After that, he has to approach the DRT.
Right, sir. Right, sir. Thank you, sir.
And another point, no stay, no injunction will be granted. Because what the earlier laws were saying, prior to this introduction of DRT, we had the civil courts also. So now, this DRT also came sometime later. I think in 2000, it came in 1993. This RDB Act, it came in 1993. So prior to that also, what the people were doing, they were taking stays, injunctions by approaching the courts. But once this DRT was established, they said nothing doing. You will not be granted any injunction. You will not be granted any stay. First of all, possession will be taken. If the bank or financial institution has declared the account as NPA and the borrower doesn't pay within the demand period of 60 days, then possession will be taken and there will be no obstruction to the possession. And once the possession is taken, then the borrower may approach the DRT that it was wrongful possession or anything like that. And if it is proved that it was wrongful possession, then penalty provisions are also there. Yes, please. Next slide.
Yeah. SARFAESI sale process, redemption and shortfall. Rules 8-9, 30 days sale notice, publication in 2 newspapers, 1 vernacular, reserve price by the authorized officer, 15-day public auction notice, 25% deposit immediately, balance within 15 days, extendable to 3 months by written agreement, sale certificate on completion. Section 13, subclause 8, right of redemption. Since the 2016 amendment must be exercised before the notice for public auction or tender or private treaty is published, not as before, any time up to actual sale. Section 13, subclause 9, consortium or multiple secured creditors. No section 13, subclause 4 measure without agreement and creditors representing less than or equal to 60% in value. Section 13, subclause 10, shortfall. The secured creditor applies to the DRT for the balance. SARFAESI is not a self-contained substitute for the RDB Act. The two run in sequence.
So here, normally, the favorite question of the examiner is on the 60%. So at least 60% of the creditors have to agree in case of a consortium. This is the favorite of the examiners. So we must remember out of this slide this 60%. Yes, please. Next.
Now, SARFAESI enforcement flow, notice to auction sale. First is demand notice, and demand notice is for 60 days according to section 13 sub clause 2. Second
Right.
is borrowers or
And even before that, we can write, first of all, they have to declare the account as NPA. They cannot issue demand notice before declaring the account as NPA. Yes.
NP. Now, second one is borrower's objection. Borrower can object and the creditor has to reply. That is, according to section 13 sub clause 3A, within 15 days, the creditor has to reply. Now, the third one is that section 13(4) is measures are triggered and possession management. There is the bank takes the possession or management or sale. Now, possession is taken in fourth one and order is taken
On
from
this
the
third
TM.
point, I have a question. Suppose it is a company. So in a company, what way the management can be taken over? Anyone from the audience? Suppose it is a company against which you are taking action. First question is whether you can take action against the company. The answer is yes. Now they want to take over the management, right? So in what way they will be taking over the management? Anyone from the audience?
Yes, sir. They can ask the ARC, sir.
No. IRP, RP is not there. This is separate act. No
ARC,
IBC,
sir.
no
ARC.
IBC is there. Suppose there is no CIRP, right?
ARC, sir. Asset reconstruction.
So by taking over the control of the majority of the board of directors.
Right. And even the shareholders, they cannot conduct any meeting without the concurrence of the secured creditor once the management is taken over.
Right, sir.
Another point is once they have taken over the management and they have been allotted shares in the company, then management will not be returned. That is also the process about which we'll learn later.
Right.
So regarding the management, we have to remember 2-3 things. Number one, no separate meetings of shareholders can take place without the concurrence of the secured creditor. And then another point we have to remember is regarding rehanding over of the management to the borrower, whether that is possible. So once shareholding has changed, so they will not return the management. They will not return the shares. Yes, please.
Yeah, possession is taken by the district magistrate, by the order of the district magistrate or chief metropolitan magistrate. Assistance, if resisted, then assistance is given by the order of the court according to section 14.
So we have to remember 30 days and 60 days here.
Now, sale process is done where the valuation notice or auction or tender is made according to rule 8 and 9. Now, auction sale is completed, then certificate is issued to the buyer and the proceeds are, if the proceeds are adequate, then debt is discharged, and if there is a shortfall, then DRT application for balance is made according to section 13 sub clause 10. Parallel or remedy at any section 13 sub clause 4 measure, an aggrieved borrower or guarantor may apply to the DRT under section 17 within 45 days. This runs alongside, not after the flow above.
Right. Yes, please. Next. So we have to remember here one thing. Besides the act, we have to read the rules also. Although I can assure you that if you go through this PPT or the video recording, you will be able to answer most of the questions. But if you construe it strictly, then you have to read not only the act, but the rules as well. Yes, please.
SARFAESI, SARFAESI registration and priority. Section 20, Central Registry of Securitization, Asset Reconstruction in Security Interest of India. particulars filed within 30 days of creation or modification extendable by a further 30 days on additional fees. Section
Right. Now
26.
regarding this section 20, I would like to tell you one thing. Number one, SARFAESI is also a sort of authority like MCA or NESL. So if you create a charge, if you are a secured creditor and you want to take action under SARFAESI, then the charge must be registered. The fees must have been paid to the SARFAESI. If the charge is not registered, then you cannot take action under SARFAESI. This much we must remember.
Section 26D, registration is a condition precedent. No secured creditor may exercise Chapter 3 enforcement rights unless its security interest is registered with SARFAESI. Verify this before any demand notice goes out.
Right.
Section 26C, registration is deemed public notice from the date or time of filing and gives priority over a later security interest or transfer of the same property. Section 26E, once registered, the secured creditors' dues rank in priority over all other debts and over central or state government dues. Taxes and cesses, the provision that usually settles contests with tax departments, operates outside insolvency. See Part D.
Yes, please. Next.
Now, SARFAESI appeals. Stages, forum and section, limitation, pre-deposit timeline. Challenge to a Section 13 subclause 4 measure. The forum is DRT under Section 17 subclause 1 and the limitation period is 45 days from the measure and the pre-deposit is disposable target is within 60 days, outer limit 4 months under Section 17 subclause 5.
So Sudhakar ji, this answers your query which you had raised. So if
Yes, sir.
any,
Yes, sir.
yes. So this is the
Yes, sir.
answer to your query. Yes, please.
Right, sir. Yes, sir.
Now appeal from DRT order to DRAT, the forum is DRAT under Section 18 and 30 days from receipt and 50% of debt claimed or determined, whichever is less, reducible to not below 25% for reasons recorded. Anticipatory protection, caveat, Section 18C, remains in force for 90 days unless the application or appeal is filed earlier. Caveator must serve notice by registered post or AD. Section 19.
Anybody who can explain this provision? What is the meaning of caveat? Anyone?
Sir, yes, sir. Sir, caveat is filed in the court where the court informs the defendant that if any if any application is entertained by the court, then first of all he should be informed about that application so that he can appear in the court. So this caveat is filed for that reason in the court.
No, just give me an example of a caveat. Who can file a caveat?
Caveat can be filed by the defendant or the person who wants to appear in the court wants to be informed.
I'll give you an example. Suppose there is a company and the company has leased its premises to somebody else. So the tenant, now tenant is also an interested party. Now the banker has taken possession. Banker has taken possession of the company's property. Now where this tenant will go? So he can file a caveat that whenever this application is being heard, I must also be provided an opportunity of being heard. Similarly, there could be a case of a mining lease where a sublessee may be entitled to file the caveat. So caveat can be filed by any of the interested parties. So if any proceedings take place, then this caveator is also served the notice by registered post AD. This is the meaning. Yes, please. And this caveat also will remain in force only for the period of 90 days. After 90 days, you have to file another caveat. Yes, please.
SARFAESI appeals. Challenge now the stage is challenge to a Section 13 subclause 4 measure. The forum is DRT under section 17(1). Sorry, this is done actually.
Yes, yes, yes.
Next slide.
Yes, SARFAESI penalty.
Yeah, SARFAESI penalties. General offense. Section 29. Contravening, attempting to contravene, or abetting contravention of the act or rules, imprisonment is up to 1 year or fine or both. Cognizance, section 30. Only an officer of the Central Registry or of RBI authorized in writing may file a complaint for offences under section 27, 28 or 29. No private or public interest complaint lies. ARC monetary penalty, section 30, subclause A, subclause 1, where the amount involved is not readily quantifiable, ceiling of ₹1 crore before any continuing daily penalty. Good faith protection, no non-payment consequences under section 30, A, subclause 4, failure to pay within 30 days, the adjudicating authority may cancel the ARC certificate of registration after a hearing. Good faith protection, section 32. No suit or prosecution lies against the secured creditor or its officers for anything done in good faith. Protects the officers personally, not a defective process.
Yes, please.
Quick check, SARFAESI Act. Facts. XYZ Bank classified ABC Limited accounts NPA, issued a section 13 subclause 2 notice for ₹5 crore, rejected ABC's objection with reasons and took possession under section 13(4). ABC Limited wants to challenge this action. Within how many days the measure must ABC Limited apply to the DRT under section 17 subclause 1? 30 days. Under section 29, what is the punishment for contravening the act or its rules? That is imprisonment up to 1 year or fine or both.
This is the answer. So the
Yes,
answer
sir.
to the first question is 45 days. Actually, 30 days is the period when you want to appeal against the action taken by recovery officer. But action against repossession, suppose somebody has taken possession and the borrower feels that the possession was taken only under 13(4), so then you can file an application within 45 days.
45 days, yes, sir.
Yes. Yes, please.
Under section 29, what is the punishment for contravening the act or its rules? Fine only up to ₹5,000 per day, imprisonment up to 1 year or fine or both, mandatory imprisonment of not less than 3 years, no punishment, only an administrative warning. Answer will be B, imprisonment up to ₹1 year, fine or both.
Yes, please. Next.
Now, interplay. How RDB and SARFAESI already interlock. A borrower aggrieved by section 13(4) measures applies to the very same DRT under section 17 SARFAESI. Within 45 days, the two statutes converge on one forum from opposite directions. An appeal to the DRT under section 18 SARFAESI requires the same 50% or 25% pre-deposit architecture as section 21 RDB. Section 13 subclause 10 SARFAESI sends any shortfall after sale to the DRT under the RDB Act. SARFAESI enforces the security. The RDB Act chases the balance. Financial institution under section 2 subclause H RDB Act expressly includes an SC or RC registered under section 3 SARFAESI. The statutes cross-reference each other's actors, not just their forums. Sir, please explain this one, sir.
Which one?
Sir, this one.
Financial?
Third and fourth.
Financial,
Third and
yeah,
fourth.
last one. Financial institution.
Actually, the financial institution under section 2H of the RDB Act expressly includes an secured creditor and reconstruction company. So if there is a secured creditor, then it is also included. And if there is a reconstruction company, that is also covered under the definition of financial institution. Actually, what this SARFAESI Act aims at, the SARFAESI Act says that, okay, and why this SARFAESI Act was introduced? Let us go to the background of the SARFAESI Act. SARFAESI Act, as you might remember, that there was one Lehman Brothers case in USA. And this SARFAESI Act, it was introduced by way of an ordinance as an emergency measure. And then later on, it was promulgated into a law. So it was introduced by way of an ordinance, and this was an act which was applicable to J&K also from the very beginning. So now in this SARFAESI Act, because please try to understand that the banks are not equipped to handle the assets. Suppose banker has given a loan, right? Now the borrower doesn't pay. Banker will take the repossession. But the question is what the bank will do with that machinery, because bankers are not equipped to handle all those things. So these reconstruction companies come in between. So what these reconstruction companies do? So they are the companies which are equipped to manage the assets. And what they will do? They will say to the bank that, okay, you are to recover 100 crores, you take 75 crores from us. And now you vanish from the scene. Now we will see. So they will enter into the shoes of the secured creditor, right? So this is the concept. So basically, the banker also removes from the scene, and secured creditor or this reconstruction company enters the scene, which ultimately manage the assets. Yes, please. Next.
The IBC moratorium overrides both truths. Section 14 IBC prohibits institution or continuation of proceedings against the corporate debtor in any court or tribunal during CIRP, DRT proceedings, and recovery officer steps must stop. Section 96 and 101 create an interim and a full moratorium for personal guarantor or individual insolvency under Part 3. Section 238 IBC gives the code overriding effect, notwithstanding anything inconsistent in any other law, including the RDB Act's own Section 34 and SARFAESI's own Section 35 non-obstante clause. Symbolic or even physical possession taken under Section 13 subclause 4 SARFAESI, where the sale is not completed before the insolvency commencement date, does not remove the asset from the corporate debtor. It must be handed to the IRP or RP.
Right. So this is also important, because unless the sale is completed, the asset will still remain in the books of the borrower. So then if the action is being taken, so then it must be handed over to the IRP or RP. Only when the books do no longer have that asset, so till that time it has to be handed over to the IRP or RP. That means unless the sale is completed, the asset has to be handed over to the IRP or RP. Yes, please. Next.
State Bank of India versus V. Ramakrishnan and another.
So we have to remember the facts of this case, because this case law is also in our syllabus. So we must understand the facts of this case. Yes, please.
Section 14 moratorium protects only the corporate debtor's estate. It does not extend to a personal guarantor. SARFAESI action against the guarantor may continue. Facts. SBI issued SARFAESI notices under Section 13 subclause 2 or 13.4 against a personal guarantor for rupees 61.13 crore, while the corporate debtor was under its own Section 10 CIRP. The NCLT wrongly stretched the Section 14 moratorium to shield the guarantor too. Reasoning. Section 14 speaks only of the corporate debtor. The guarantor's liability under Section 128 of the Indian Contract Act is coextensive with the principal debtors and independently enforceable. Reading a stay into it would defeat the very purpose of taking a guarantee. Linked to RDB or SARFAESI practice, confirms banks may pursue SARFAESI against a guarantor's personal assets even while the principal borrower is in CIRP, decisive for forum and timing advice under Part D.
So I hope everybody is clear about this case. So it says
Yes, sir.
that even if the company is into CIRP, section 14, the moratorium, the stoppage of action against the borrower, it will apply only to the company. In this case, the company filed an application under section 10 on its own. But they said, Supreme Court said that action against personal guarantor can be taken despite moratorium being in place. Yes, please. Next.
Jenny Thankachan versus the Union of India and others. Held, the Section 96 interim moratorium protects the personal guarantor only once the Section 94 application is complete and formally registered. A mere diary number does not suspend a pending SARFAESI action. Facts. A guarantor tried to stay a bank's SARFAESI proceedings by filing a Section 94 application. The application had only been assigned a diary number and was never registered by the NCLT owing to procedural defects. Reasoning. Section 238 overriding effect cannot be invoked on the strength of a defective, unregistered application. The court followed SBI versus Ramakrishnan on the moratorium's limited reach to guarantors. Linked to RDBI or SARFAESI practice. A practical checkpoint before advising a guarantor client that SARFAESI enforcement is automatically stayed, verify the registration status of the Section 94 or 96 application first.
So sometimes what the borrower does, so what the guarantor does, sometimes he manages certain things, right? But unless it is formally registered, merely a diary number will not stop action against the guarantor. And this case law is also in our syllabus. Yes, please. Next.
Next one. The Recovery Certificate and Personal Guarantor Forum. A recovery certificate is issued under the RDB Act gives rise to a fresh cause of action. Its holder is a financial creditor entitled to file Section 7 IBC within 3 years of issuance. For individuals and partnership firms, the DRT itself is the adjudicating authority under Part 3, admits the process, approves or rejects the repayment plan, passes the bankruptcy order, appoints the trustee. Section 60 subclause 2 IBC exception where CIRP or liquidation of the corporate debtor is pending, an application against its personal guarantor must go to the NCLT, not the DRT. Getting the forum wrong at the outset is a fatal avoidable delay.
So here we have to be very cautious about this recovery certificate. So a recovery certificate is also some sort of evidence of a financial debt. So its holder, so if there is a holder of a recovery certificate, then he is entitled to file Section 7 application within the limitation period, within 3 years of issuance, right? So if a recovery certificate is issued, recovery is not effected, then within 3 years of the issuance of recovery certificate, the secured creditor can file an application under Section 7 simply on the strength of the recovery certificate. Yes. Yes, please.
Priority outside insolvency and the 2026 correction. Section 26 is SARFAESI priority over government dues operates outside insolvency. Once a liquidation order is made, distribution instead follows Section 53 waterfall subject to the secured creditor Section 52 election. State tax officer versus rainbow papers.
I think we can skip this slide because this amendment came in 2026 and the cutoff date for our syllabus is 4th of February 2025. So if you are appearing on or after 1st October, then this slide will be effective. But for students who are appearing before 1st of October, this slide is not of much consequence. So next, we can move to next, please.
State tax officer versus Rainbow Papers Limited. held a statutory first charge example, Section 48 GVAT Act makes the state a secured creditor under Section 3 subclause 30, 3 subclause 31 IBC. A security interest can arise by operation of law, not only by agreement. Such dues cannot simply be waived in a resolution plan. Facts. Gujarat's VAT department claimed secured creditor status in Rainbow Papers CRP by virtue of a statutory first charge. The resolution professional had treated the claim as waived under the approved plan. Reasoning. The word satisfied in section 31 subclause 1 casts the real duty on the adjudicating authority to test the plan against section 30 subclause 2. A plan that ignores a legitimate secured statutory claim fails that test. Link to RDB or SARFAESI practice. This is the very ruling the IBC or Amendment Act 2026 legislatively reverses by narrowing security interest to consensual charges. Only see the earlier slide. Know the holding you are now applying the 2026 correction against.
Actually, by virtue of this amendment in 2026, which is not in our syllabus, this judgment in a way was reversed by virtue of amendment in the act. So they amended the definition of security interest. But for your syllabus, what is the law? The law is that security interest could be created by operation of law, right? And Gujarat VAT Act, it allows the secured creditor to have his rights as per section 53. So it says security interest could be created by operation of law. Now I'll explain what is the amendment now. Although it is not in your syllabus, but it may be of interest. The amendment now is that there has to be a separate written agreement or arrangement besides simple statement in the law. So they say that, okay, I'll give you an example. Suppose your case is before an income tax tribunal. Now, Income Tax Act also says that the income tax arrears can be recovered as arrears of land revenue. But Section 238 of IBC comes into play at that stage. But suppose you agree before the tribunal that, okay, you will deposit this much amount. Or suppose there is some voluntary disclosure scheme and you agree that, okay, you will be depositing this much amount. So once that agreement or arrangement is there, the word used in the amendment is agreement or arrangement. So if that wording is there, then they will be allotted the status of a secured creditor, not otherwise. But as far as your syllabus is concerned, this is the ruling that rainbow paper applies, right? I hope you got it. Next.
Secured creditors during CIRP. The moment the moratorium under Section 14 IBC commences, a secured creditor's RDB or SARFAESI enforcement rights are frozen. No fresh Section 13(4) action, no DRT execution. The secured creditor files its claims with the IRP or RP like any other creditor, and if a financial creditor sits on the committee of creditors, voting weight tied to the value of its financial debt, not merely its security. Possession already taken under Section 13(4) but not followed by a completed sale before the insolvency commencement date does not defeat the moratorium. The asset returns to the corporate debtor's estate for the RP to deal with. A secured creditor cannot jump the queue via SARFAESI once CRP begins. Its remedy is inside the process through the resolution plan or later liquidation.
So one important thing to remember here is that during CIRP period, whether you are a secured creditor or whether you are an unsecured creditor, you both have got the same voting right. So there is no change in the voting right, even if you are a secured creditor. Both of you stand on the same footing. But while evaluating the plan, naturally, the liquidation value is ensured, and the liquidation value could vary between secured creditor and unsecured creditor, right? So you have to remember Section 30 subsection 2, which talks of the liquidation value to dissenting financial creditors and operational creditors. So to that extent, secured creditor is at an advantage during CIRP also, but otherwise, as far as voting rights are concerned, there is no priority to secured creditor. Both are at the same footing. Yes, please. Next.
Illustrative ruling: secured creditor obligations persist. A secured creditor that elects to realize its security outside the liquidation process does not thereby escape its statutory contribution obligations. According to Section 13, Subclause 9, SARFAESI dues example towards workmen survive the election to realize outside the estate. Teaching point for opting of the liquidation: Section 52 is not a clean exit from every obligation the court attaches to that election. Cross check Section 39 SARFAESI alongside Regulation 21A each time. Secured creditors in liquidation, the Section 52 election. Section 36 IBC: on commencement of liquidation, all assets of the corporate debtor form the liquidation estate, subject to the secured creditors election under Section 52. Option 1. Relinquish. The secured creditor gives up its security interest to the liquidation estate and receives repayment through the Section 53 waterfall. Option 2 is realize. The secured creditor stands outside the estate, sells the secured asset itself, and if there is a shortfall, proves for the balance as an unsecured creditor under Section 53 subclause 1, subclause E, subclause 2. Any surplus must be accounted for and tendered to the liquidator under Section 52 subclause 7. Regulation 21A subclause 2 subclause A obligation. The secured creditor realizing outside the estate must still contribute its share towards liquidation costs and workmen's dues. HDFC Bank versus Hema Engineering Industries 2025 NCLAT confirms this 90-day contribution is mandatory and not conditional on the security actually being realized.
Yes, please. This is another important case, Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat. And this is also in our syllabus. Yes, please.
Held. In liquidation, unlike CIRP, a secured creditor holding a statutory charge must release its attachment and participate through the Section 53 waterfall. Rainbow Papers is confined to the CIRP context and does not displace Section 53 in liquidation. Facts. PVVNL held a statutory charge for unpaid electricity dues and had attached the corporate debtor's assets before CIRP. After the debtor moved into liquidation, PVNL sought to auction the attached property outside the code. Reasoning. Section 14(1)(c) bars enforcement during CIRP. Once in liquidation, a secured creditor's rights run only through relinquishment or the Section 52-53 route. A relinquishing creditor ranks well above one who tries to enforce independently. Linked to RDB or SARFAESI practice. The direct authority behind Part D Section 52 election anchors why relinquish versus realize is the choice and why the 2026 amendments value cap priority builds on this very logic.
Actually, the 26th amendment is not in our syllabus, but still this case law is in our syllabus. So what it says that during CIRP it is different, but during liquidation is different. So in Paschimachal Vidyut Vitran Nigam Limited also, what the party tried to, they tried to make a parity between this section and the Rainbow Paper judgment. But the Supreme Court said that Rainbow is confined to CIRP only and not to liquidation. Yes, please. Yes, next.
Yeah. Quick check. Case law on RDB or SARFAESI and the IBC. In State Bank of India versus Ramakrishnan, the Supreme Court held that the Section 414 moratorium Automatically extends to personal guarantors of the corporator, applies to personal guarantors only if Part 3 of the IBC is in force, has no application to personal guarantors, only the corporator is covered, extends to personal guarantors if they are also directors of the company. The answer is C, has no application to personal guarantors, only the corporator is covered. In Pashmanchal Vidyut Vitran Nigam versus Raman Ispat, during liquidation, the secured operational creditor could retain its attached property and not participate in liquidation, had to release the attached property and participate under Section 53, could enforce its security interest independently without joining liquidation, was entitled to full repayment before distribution to other creditors. The answer will be B, had to release the attached property and participate under Section 53.
Right. Yes. Next. So this 26th amendment we can leave for the time being, right? Now 43. Let us move to slide number 43. Because this summarizes the entire discussion.
The 220, okay, key takeaways or for practice.
Yes.
Threshold and forum first. RDB Act applies only at rupees 20 lakh plus confirms the SARFAESI registration section 26D before any SARFAESI demand notice goes out.
And plus NPA, plus declaration
NPA.
as NPA. Yes.
Yes. Track the 45 or 30 day and 50% or 25% appeal architecture in both acts. A missed pre-deposit or limitation date is fatal, not curable by merits. The instant a moratorium is notified, Section 14 or 96 or 101 IBC, stop RDB or SARFAESI action and switch to claim filing before the IRP or RP or liquidator. In liquidation, the Section 52 election is now time boxed 14 days or it is deemed relinquished. Calendar this on every new liquidation engagement. Priority is no longer automatic on the full debt. Only the value of security relinquished. The balance is an unsecured claim under the recalibrated Section 53. Re-verify all the above against the current text on ibbi.gov.in. This is one of the fastest moving corners of the code right now.
Now regarding this liquidation, this 52 election, the time period now is 14 days. But this is for your syllabus. As far as your syllabus is concerned, it is 30 days. So within 30 days, you have to exercise the option. But now, by virtue of this 2026 amendment, now it has been shortened to 14 days. But for your syllabus, it is 30 days. Yes, please.
MCQ. Under Section 13, subclause 10 SARFAESI, where sale proceeds fall short of the debt, the secured creditor's remedy for the balance lies before the NCLT under Section 7 IBC directly, the Debts Recovery Tribunal under the RDB Act, a civil court of ordinary jurisdiction, the Central Registry, SARFAESI. So the answer will be the Debt Recovery Tribunal under the RDB Act, B. Where symbolic possession was taken under Section 13(4) SARFAESI, but the sale was not completed before the insolvency commencement date, the asset stays with the secured creditor outside the moratorium, must be handed over to the IRP or RP as part of the corporate debtors' assets, vests automatically in the government, is auctioned by the DRT notwithstanding the moratorium. The answer will be B, must be handed over to the IRP or RP as part of the corporate debtors' assets. Under the IBC Amendment Act 2026, a secured creditor who wants to realize its security outside the liquidation estate must intimate the liquidator within 7 days, 14 days, 30 days, 90 days.
So
The
as far
answer
as your syllabus is concerned, the answer will be 30 days, but this 2026 amendments restricts it to 14 days. I'll amend it accordingly. I'll mention both the things.
Okay, sir.
Yes, please.
After the 220 recalibration of Section 53, a secured creditor's priority Entire entitlement is measured by the full amount of debt admitted, regardless of security value. The value of the security interest actually relinquished, any balance ranks as unsecured, a flat 50% of the admitted claim, and whatever amount the committee of creditors approves.
Actually, earlier the answer was A, but now
B will be the answer.
Now B is the answer.
Yes.
Yes, please. So, if you have any questions on this, so this completes our today's deliberation. Just a minute. So, thank you very much, Kajal Kiran Rai ji, for this.
Thank you, sir.
So, you did it very finely. But still, we have left 2-3 things. Can anybody tell what are the points we have missed in SARFAESI?
Sir,
One
sir,
is regarding reconstruction companies, ARCs.
Yeah, ARCs, yeah, that
In
is
ARC,
RBI
we
is
just
governing and all.
100 crore, but other things we have missed, like these are being regulated by RBIs and they have to inform if there is any change in management, etc. So we'll be putting up in the group regarding those things. So you can just, I think one slide will cover the entire ARC period. Another point is regarding the qualified buyers, qualified institutional buyers. Because now let us try to understand the process. In SARFAESI, how the things move. In SARFAESI, you know that the borrower is unable to pay. Now possession is taken. Possession, what the banker will do with the possession? Banker is not equipped to handle all these things. So banker will hand over that asset to a secured creditor. Now that secured creditor is normally the asset reconstruction companies. Right? So asset reconstruction companies, what they will do? They will charge their commission and pay the amount to the banks. So bank will be out of picture. Bank's balance sheet will be clean, right? And now the asset has landed to the ARC. Now another question is what the ARC will do with that asset. So ARC also issues scrips to qualified institutional buyers and they get the money from them and they assure them that okay, they will be repaying or they will be giving them interest. And if the ARCs do not pay to the qualified institutional buyers, then qualified institutional buyers can take over the management. So these are some of the things which we have left in the PPT, but I think we'll give you another 2-3 slides and that will cover this point. And in the all the meetings now onwards, the qualified institutional buyers, they will also be entitled to attend those meetings. And if the ARC is not paying them the promised interest or repayment, then the qualified institutional buyers, they can also conduct the meetings. So these are some of the points which I think we can cover. Let me share with you another PPT. Just a minute. I'll take just 5-10 minutes, not much. Most of the things we have already covered. So I hope my screen is visible. Is it visible?
Yes, sir.
Okay. So what we will do? We'll skip the slides we have already taken. This is the roadmap. These are the case laws covered. This we have already covered. So I have introduced another slide of the stakeholders. So what are the various stakeholders? The stakeholders could be bank, financial institutions or asset reconstruction companies, right? So because we have to view it from that point also, that what are the parties involved? Borrower guarantor, DRT or DRAT, IRP, RP or liquidator, SARFAESI. Now regarding SARFAESI, if you read the provisions in detail, there are provisions of say penalty also if you do not get your asset registered under SARFAESI. Another point is whether an unsecured creditor can take action under SARFAESI. The answer is no. Right. Now, another point is, suppose the secured creditor doesn't get the charge registered, then the borrower itself may ask the authority that, okay, you please register my charge. You need not remember the fees part because there are fees and penalty provisions also in SARFAESI. So I think the examiner will not go to that length. This we have covered already. This we have covered. RDB Act. Penalties we have covered. This we have already covered. SARFAESI. Most of the things we have already covered. Just let me show you something which we have left. So these are some of the other case laws. Now let us see the interplay. So one case is Encore Asset Reconstruction Company versus Charu Sandeep. It may or may not be in your syllabus. I don't remember. But actually these cases will help you in solving the case studies because both SARFAESI, DRT as well as IBC is in your syllabus. So let us see this case where the RP won the case. So a secured lender that has already taken physical possession of mortgage property under SARFAESI before the CIRP was admitted must still hand over that custody to the IRP or RP. So here they have taken the physical possession, but please understand that sale has not taken place. Simply physical possession has been taken. So they will divulge only these facts. They will not elaborate whether sale has taken place or not. So if they have not written anything about sale, so you have to assume that only physical possession has been taken and no sale has been effected, right? So here physical possession only has been taken before the CIRP is admitted. And in this case, RP said that, okay, I am entitled to possession, and it was rightly held that, okay, the borrower should hand over that custody to the IRP or RP. So section 18, they say it prevails over section 13(4) of SARFAESI. So here the banker had taken the possession, but now the bankers were asked to give the possession to the IRP or RP. So this could be asked by way of a case study. Indian Overseas Bank versus RCM Infrastructure. This is another case where RP won. So transfer of ownership in a SARFAESI sale is complete only on issue of a sale certificate, not on possession and not on confirmation of the auction. So even if there is a confirmation of the auction, still if sale certificate is not issued, then also it has to be handed over. So where the balance sale price was received after the moratorium began. So here the sale had taken place. Auction notice issued, auction completed, but balance sale price was received after the moratorium began. So it says the sale stood incomplete and the bank's SARFAESI action could not continue. So these could be some of the questions which could be framed in a case study. So if we remember this, I'll share this slide also with you. So when the RP asks for repossession, so these are some of the things. Another cases, here the bank one, Punjab National Bank versus Amrit Hatcheries. So it's not important whether these are in our syllabus or not, but for understanding the purpose and for solving case studies, these cases could be helpful, right? So where the SARFAESI auction sale had already concluded. So in this case, auction sale is concluded, full payment received, sale certificate issued before the moratorium was declared. Properties cannot be treated as liquidation assets of the corporate debtor at all, right? So this is just the reverse case where the bank won, where everything was complete before CIR was commenced. Then Kotak Mahindra Bank versus Q Precision Parts Private Limited, another. Here also the bank won. written signed acknowledgement or promise to pay a debt, including one made after the original limitation period has run, is a fresh promise under Section 25(3) of the Indian Contract Act and revives the financial creditor's right to file under Section 7 of the IBC. So here, what was the fact? This Kotak Mahindra Bank's account with the Q Precision Parts turned NPA on 30th of September. NCLT had allowed the suspended director's appeal and set aside the NCLT's admission of the bank's Section 7 petition, holding the application is time barred and rejecting the bank's reliance on the corporate debtors' later written acknowledgement of the debt. So it allowed the appeal. And now the Supreme Court held that Section 238A, it imports the Limitation Act, and with it, Section 25(3) of the Contract Act, a written promise to pay time-barred debt signed by the debtor is a fresh, independently enforceable contract, even though the original debtor's remedy is barred by time, right? So it's a reminder that the corporate debtor's own conduct. So if he has confirmed the balance, or if he has made part payment, or if there is a written acknowledgement, so it can hand the secured or financial creditor a second life on limitation, defeating a challenge the corporate debtor, and functionally an incoming RP would otherwise have won on a time barred alone. So here the bank won the case because they had the written acknowledgement. Pachimanchal we have already covered. 26th amendment we can leave. So this completes. So there are just one or two more things. Number one, regarding this asset reconstruction companies, right? So regarding that, I will put another 2-3 slides on the role of the ARCs, because these are being regulated by RBI, and if there is a change in management, then they have to inform, right? There is a concept of an anchor also, sponsor also in asset reconstruction companies, but most of it stands completed. So if you have any questions, you can ask. Otherwise, it completes the today's deliberation on this